second half court is not there. So
Yes.
those things have to be adjusted.
Yes, ma'am.
Just for information, I am not saying anything. What you are saying is absolutely fine, perfect. No issues. Yes. Video.
Withdrawal fine.
Aji ଅଛି ନା କୋଉ ଦିନର?
Item 7.
7 ଟା withdrawal. Yontu?
With the liberty to file a better application, ma'am, because there is some facts are not, ma'am.
If it was argued earlier, and considered and
Fresh admission.
ସେଥିପାଇଁ ତ କହିଲି ସାର୍ ଫ୍ରେଶ ଆଡମିସନ ନ କହିଥିଲେ ଏଇଟା କଣ କହିବି ମୁଁ ପ୍ରଫେସନରେ ଦ୍ୟାଟ୍ସ ଦ ବେଷ୍ଟ ପାର୍ଟ ଅଫ ଇଟ୍ ଇଟ୍ସ ଏ ମଲ୍ଟିଟାସ୍କିଂ ମୋ କହିବାର କଣ୍ଟେକ୍ସଟ ଆପଣ ଯେତେବେଳେ ଏଇଟା ଯଦି ଆର୍ଗ୍ୟୁ ହେଇଥିଲା ଫ୍ରେଶ ଆଡମିସନରେ ଆସିଛି ତାହେଲେ ଗୋଟେ ଡିଫରେଣ୍ଟ ଯଦି ଆର୍ଗ୍ୟୁ ହେଇନି ତାହେଲେ ଡିଫରେଣ୍ଟ ବୁଝିପାରୁଛନ୍ତି
Argue ହେଇନି probably.
ଦ୍ୟାଟ୍ ଇଜ ଦ ୟେସ୍ ଏଇଠି ଅଛି
And the without the madam, certified copy is substituted by the photostat.
ଓକେ ଆପଣଙ୍କ ପାୱାର ଅଛି
Madam, assess this.
ହଁ ଅଛି ଅଛି certified copy to be replaced ହେଲା ରିପ୍ଲେସ୍ କରିଦେବେ ରିଟର୍ନ ହେଇପାରିବନି ରିପ୍ଲେସ୍ ହେଇଯିବ with attested photocopy.
Lordship, I have an innocuous query, Lordship. Subject to Lordship's convenience, can the item number 35 be taken up as a last item, my Lord?
No preference. You have to shift to Delhi, become outstation council, at least to the neighboring state. Instead of Bhubaneswar, you go to the neighboring state, mention that I'm outstation council. Those are being accommodated because they will disturb the entire list.
This matters actually when listed since last 3-4 days, but
Can it be attributed to court? It cannot be.
it cannot be, my Lord.
Attributed to the number of cases and the nature of determination.
It's a TRPC matter, my Lord.
Whatever.
5 minutes
TRPC
hardly it will take, my Lord.
TRPCs are argued 2 hours.
They will not take 2 hours, my Lord. This matter will not take.
I really imagine how it was argued by whom and how the judges could withstand it. If you read Kesvananda Bharat, the number of opinions rendered by the honorable great judges, it's impossible. I cannot handle a TRPC, it is argued for 2 hours. Order 6, Rule 17, 2 hours, 20 minutes, again adjourned. Amendment of pleading is argued. Even the suit will not be argued that much. So what can be done, sir? Either it has to be, you have to, like America, you fix a time, even if you cannot complete a settlement, because you are starting with subject to Lordship's. If
Convenience.
the time the watch touches it, you have to sit down. So that I don't know how. See, again, I'll highlight that I am not finding any fault. Everything is perfect, and there is I mean, some cases have been kept pending. Those are interlocutory in nature. So there are so many aspects. I can't find fault. Your point is well taken. TRPC matter kahi pending rahe.
Lordship,
Reasoning now it is a computer is listing. So
what is
your
happening? my
wise
Lord?
listing.
Stay order is there.
So
the petitioner
if you agree,
time.
so
my Lord,
they are mediation will help. Suppose both of you agree for a place. TRPCs are argued by a senior counsel. 2 hours, 2.5 hours. Because I cannot, I can tell you the case and place and the lawyer's counsel. So difficult.
22.
Page wise,
Page
hame jauche. Mr. Vidyabhushan, page wise we are going.
Page 1, 1 to 6.
Item 12, Lordship, may I pray to chapter, my Lords. Item 12.
Order se kahi ke adjourn korchundi kichi to order hele se matter ta bole date habo.
My Lords, I was directed to take instruction in the matter, my Lords, on the last
matter
order.
was heard at length. Mr.
Yes, sir.
R.N. Raut
Yes,
for
sir.
the petitioner. Hybrid mode lekhibe. The Lord Counsel being present in the VC addresses arguments. Stuff. He mentions the matter being in the list for adjournment. Stuff. The matter was earlier heard at length on 17/3/2026 at some length. And adjourned at the instance of the learned counsel for the petitioner to enable him to obtain instruction regarding the issues noted in the said order. Okay. As prayed for, the matter shall be listed for orders in the week commencing 6-7.
My Lords.
Vacation pore to?
My Lords.
6 7 20 26.
Item 13, my lord.
Yes, 13, Mr.
13, I am praying for my lord.
Mr.
chapter-
A.K. Naik for the petitioner. Same, earlier had same order, same Saturday, everything same. Mr. Naik, into appears in this is a particular, unfortunately. A.K. Naik for the petitioner, opposite party blank. Dates after vacation.
My lord.
David, date कौन सा?
We commencing 6 sir.
We commencing 6.
Page 3,
Item number
14 to 19.
Item number 13, permitted
1 4. 1 4. Revision ना अच्छा आपण मेमो फाइल करछंती
Right.
साइन बाय यू सर आपण को नाटा
GR Das.
साइन करछंती आपण
Right.
ओके विड्रॉल
Item 16. One
इन्फॉर्म
week
अदर साइड इन्फॉर्म कर दियो से नाहंती
Item
16
16.
yes
1 week after.
आपण को ना सर
Chitran CR Barisal.
टी बरिसल
Barisal.
बरिसल 16 Mr. C Barisal for the opposite party. Who is for the Mr. Perda? Petitioner के नांती देखो एंट्री मर्डर अछि
No, no interim order.
ताउटे इन्फॉर्म करंतु आपण ऑर्डर सुडा अर्जन कर दोछंती एवरीवन एक्सपेक्ट्स द ऑर्डर अर्जन होबनी दे विल कम टू कोर्ट
Actually, two writ petitions
सर
are.
एक्चुअली मु जोटा कोची कोन सेटा ऑनजे
No, no.
सो व्हाट आई से आल्सो यू हैव टू इन्फॉर्म द अदर साइड इज वेरी रियलिस्टिक
Sure.
व्हाटएवर मे बी द एक्चुअल हैपनिंग और when
I'll do.
lawyers should not tell the actual happenings. May not tell lies, but always not tell the actual happening. That creates a lot of problem.
This item.
Once order like that. The Lord Counsel for the opposite party. Acha, you have appeared.
Yes.
The petition was heard at length in presence of the Lord Counsel for the petitioner as well as the opposite party on 21-26. The facts and the legal issues were noted as reflected in the said order. The order of the said date as reflected in the order of the said date. Today, the matter being in the list is mentioned by the Lord Counsel for the opposite party. He seeks adjournments. Adjournment. The matter shall be listed for orders in the week commencing
6 sir.
6-7 হবো তো
Yes.
6-7-20-26 सेकंड मैटरটা কোন স্যার সিবি আপন পিটিশনার আর আপন অপোজিট পার্টি
Both the opposite, but the copy has not yet been served. Two.
আপনি তো নাহাନ୍ତି ଆପଣ মেনশন କରୁଛନ୍ତି ଆଉ କଣ କରାଯିବ ସିନା ଥିଲେ ଆପଣ ତାଙ୍କ ଗୋଟେ ଆଉଟ ଅଫ ଟର୍ନ ମେନଶନ କରିବେ ସେ ନାହାନ୍ତି କହିବେ କପି ସର୍ଭ ହେଇନି 758 ରେ ସେୟା
7. Dita agar copy serve नहीं.
କେମିତି ହବ ସେଟା ସାର୍ 758
Not yet appeared.
ସେ ଯଦି ଆସନ୍ତୁ ଆପଣ ଆପିୟର କରିବେ
Actually, I don't have the writ petition. Copy has not been certain.
ଆରେ ରିଡ୍ नो ଇନଷ୍ଟ୍ରକ୍ସନ ସାର୍
No instructions.
ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ଆପିୟର କରିବାର
No, actually, those two.
ଏମିତି ଗଲେ କି ଆପଣ ଗୋଟେ ଆପିୟର କରୁଛନ୍ତି କନେକ୍ଟେଡ ମ୍ୟାଟର ଆଉ ଦିଟାରେ
On the
କହୁଛନ୍ତି
last
ଆପିୟର
occasion-
କରିବାକୁ ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ
Millard on 20th, actually, Millard on the request of the petitioner, these two writ applications were actually clubbed up together.
ଯେ କଣ କ୍ୱେଶ୍ଚିନ୍ ସାର୍ ଆପଣ କଣ କହୁଛନ୍ତି ତାହେଲେ ଯଦି ମୁଁ ପଚାରିବି when the how it has been clubbed up ତାର ଆନ୍ସର କଣ ହବ
No, because
ଆନ୍ସରଟା କ୍ୱେଶ୍ଚିନଟା କମ୍ପ୍ଲିଟଲି କଣ୍ଟେକ୍ସଟ ଇଜ ଡିଫରେଣ୍ଟ କନେକ୍ଟେଡ ରିଟ୍ ପିଟିସନରେ ଆପଣ ଆପିୟର କରୁଛନ୍ତି
no,
party
not
ସମାନ।
yet, not yet appeared. Not yet appeared.
ଆପଣ ନିଜେ ମେନସନ କଲେ
No, no, not yet appeared.
ମୋ ପାଇଁ କହିଲେ
Not yet appeared. Only on this
GUAP 16 ରେ ଆପଣ ଆପିୟର
appeared.
କରୁଛନ୍ତି
Yes.
ତା ସାଙ୍ଗରେ ଟ୍ୟାଗ୍ଡ ଅଫ୍ ମ୍ୟାଟର ଅଛି ଦିଟା ରିଟ୍ ପିଟିସନ
Dita agar I have not yet appeared.
সেটা তো করুনাহান্তি, সেটা পচরা হচ্ছে আপনাকে যে এমতি হলে কেমতি হব ট্যাক্ট অফ ম্যাটারে আপনার গোটাকে আপিয়ার করিবে আর দুইটারে কইবে যে মু আপিয়ার করিবিনি বলি সপোজ
The
Notice দিব না কোন?
notice has not been issued.
should not be issued. আরে যদি
You have to-
if I issue notice in that matter then people will laugh at me.
Okay, I'll appear, but I'm not yet
So
instructed.
Vidyabhushan will comment. সেটা কেমতি হব আপনার সে তারপরে আপনার কপি পাইনা যদি মু হাউ আই উইল পাস এ অর্ডর ইন देयर absence behind their back ঠিক রহি পারিবে আপন 16 পড়িলা যায় adjournment হব যে বট আপন কপি নবা পে ডাইরেকশন কেমতি হব আফটার মেনশন করি তে অর্ডারটা 16টা সেপ্টেম্বর আউটরে করে পড়ে piecemeal argument will never help you. ଆପଣ ବି ଯଦି appear କରିବେନି ତାହେଲେ instruction ନାହିଁ ତାହେଲେ ସେଟା clearly କହିବେ so that the court will decide what to do. ସେଟା ବି ଆପଣ you can't be this way. te ଅପେକ୍ଷା କରନ୍ତୁ. Yes, 17
Item 17, ma'am. After vacation.
है 16ଟା ନା 17ଟା ଭୁଲିଗଲେ କୋଉ ଅର୍ଡରଟା ଭୁଲିଗଲେ 16ଟା ପଢିଲା ବେଳେ ଡାକି କରିବେ ଭାଇ 16 ତ ଅର୍ଡର ହେଇନି ଆଉ
Item 17, ma'am. After vacation.
Mr. Subhasis Mahapatra for your Subhasis Mahapatra.
Yes, sir.
Petitioner. The petition was heard at length on 17/3/2026. The issues, the facts and the legal issues were noted in the said order. In the order of the said date. Today, the matter being in the list for orders, Lord Counsel for the petitioner mentions and seeks adjournment. Stop. Accordingly, the matter shall be listed in the week commencing.
Sure, sir.
The execution pending achi.
Execution pending.
Copy of this order shall be forwarded to the lauded Judge Judicial Magistrate First Class Bodamba. Takari pakari achi pending.
Okay.
To be kept in the records of CRP number 13 of 2016. Along with copy of dated 17/3/2026. Yes.
So item 18, my lord. Item 18 appearing for the petitioner in this case, kindly be adjourned to any other date. my lord.
18 re Mr. Lenka, your matter. 18.
Yes.
Maybe you or Mr. Prabhu or Prem date कर दो.
वो कौन सी 11/7
Any other matter? Page 4.
Item 22. On behalf of Mr. Vishnu Prasad Swine, I will file rejoinder, my lord. Counter file. I will file rejoinder. let it go.
22 ଟା তাহলে ଆପଣଙ୍କର simply date ହବ. ହେଲା 22 ରେ date କରନ୍ତୁ.
वो कौन सी 11/7
22 ଆପଣ Mr. Patra.
Mine.
Your presence is to be noted.
Mine.
Mr. ଆପଣଙ୍କ ନାଁ ନାହିଁ sir.
M.K. Mantle, on behalf of Vishnu Prasad.
Mr. M.K. Mohanty on behalf of Vishnu Prasad Swine for the petitioner. Mr. Sudhir Kumar Patra, standing counsel for OP number.
For accountant general.
Mr. Lenka ଆପଣ
Prabhu Prasad.
Mr. Prabhu. So Prabhu Prasanna Behra, ASC for OP number 1 and 11345. 1345. Mr. Sudhir Kumar Patra, standing counsel for OP2. The matter being in the list is mentioned on behalf of the learned counsel for the petitioner, seeking adjournment to file rejoinder. So accordingly, the matter shall be listed. Called date को
वो कौन सी 11/7
in the week commencing 11/7/2026. So, para the rejoinder on behalf of the opposite party shall be filed. केबे फाइल करिवि?
27.
Shall be filed by 18/5/2026. Serving copy thereof on the learned counsel for appearing for the opposite parties. The opposite matter is listed. Matter being listed for admission hearing. Or listed for hearing under the list admission. For it. Yes.
Page 5 26 to 33
Item 31.
31, sir.
I have taken consent, let it come after vacation.
31 posting.
I'm for the.
We commencing 11
item 31.
We commencing 11 साथ है.
My lord, the direction may be given to the petitioner to supply his.
He has approached.
Copy of.
Yes, today morning he has approached. I will serve a copy.
Notice रे copy पाइना है अपन.
पठेइथिली.
Request करियो ना.
Yes.
Yes.
Okay.
36, 34 to 40.
My lord, pardon.
Okay.
And item 40, my lord.
Yes, 40.
I am 40. I am the respondent, my lord.
Yes.
I am filed a objection.
Okay, ठीक है. Hearing matter though today bench will not be available, but still then it is informed. Madam, yes. The date के बे कौन? You suggest the date. See the adjournment चाहो नहीं. अपन date कौन? After vacation. ठीक है. 40 से posting
We
कर
commencing 11/7.
We commencing 11.
Pardon, my lord.
ଆପଣ 6-7 ରେ 30 ଟା apply କରିଛନ୍ତି. ଦେଖ ଅନୁସାରେ
The execution is pending.
देखियो आपण GUAP रे execution is difficult. GUAP section 9 restitution of conjugal rights. तर execution टा कोन है छुआ को नै कि आपण पठेबाटा से हे परियो. Let us see.
Item 38, my lord.
Again
38.
38 sir.
My lord, I pray for 4 weeks time to file counter.
Sir Nayak.
My lord,
Oh yes. 38 after vacation. Simple
After
posting हे गला.
We commencing 11/7.
Pardon to mention, my lord.
Entry mode पर post माने adjournment थिला ना stay थिला. Stay रे I am not touching. That saves lot of time. For adjournment if you simply do it in the computer दरकार नहीं किछ.
Pardon to mention, my lord.
यदि किछ stay interim problem हो किछ रे अछन कोन.
that is there, my lord.
No, they are very positive.
Pardon, my lord.
Yes,
Item
please.
number 37.
Time sir.
My lord, this matter, I am for the opposite party. Here, your lordship, twice this matter was listed, but petition is not coming and I have already filed the counter affidavit. My humble submission before lordship.
Hearing matter is sir it cannot
My
be
lord,
predicted
my humble submission.
top down रे आसीबो बोली हबनी.
No. Let the matter come next week on the top of
Next
the
week
list.
adjust करिया पड़ो.
Sir,
Sir, I told you sir how many
My-
matters have to be
last
adjusted
week
to
रे-
specifically adjourn होची ता तो list करिया पड़ियो ना.
Last
अगर अन्य matter आसीबो.
last week रे आसो हजूर.
देखो नु केबे से. ओ
Last-
लास्ट कर दियो छुट्टी पूर्व.
We commencing 18/5.
Yes sir.
Item 40 ଟା जो ସେଇ 18 କି 19 ରେ ଗୋଟେ ରଖନ୍ତୁ ନା 18 ତାରିଖ
Recommencing ए 18 रे करियो. ये रखो. ठीक है.
18 मे
11 ना 18
ए आपण डिसाइड करंतु.
हाँ 11 में
11th week रे केबे से आनिबे सेटा कहि परियोनी. Because it is better to be in the week so that it is adjusted, distributed. Specific date है difficult, it becomes difficult to list matters. List to कटि जियो तापर. Understand? It is kind of a weekly list. No name supplementary but adjourned and distributed over the week. Yes. केबे रखियो. आपण 18 रे रहिबेनी कोचन.
वो 18 आउट ऑफ स्टेट
19 रे रहिबे ना. से week गला आपण वेकेशन में पळेले. ठीक है. Commencing 11.
obligation.
Item 1.
Item 1, my lord.
Please.
The last occasion, my lord, it was heard and then order.
Yes. Mr. P. Balakrishna for the petitioner. The Lord counsel for the petitioner refers to the order dated 23/23/2026. On the same date, the Lord counsel for the petitioners were heard at length. The facts and the legal issues were noted in detail. Yes.
And my lords have directed me to take instructions. I have already instructed him over phone and he is coming on this Saturday. For
You want adjournment?
I want to adjourn.
The
Another
Lord
thing,
counsel for the petitioner seeks adjournment to enable him to obtain instruction.
let it be on Wednesday.
No, Wednesday not possible, sir.
No, why I'm saying that there can be a settlement.
You said that, sir.
No,
For settlement, presence in court is not necessary.
No, no.
Please appreciate that.
The other side has appeared.
If you agree for the settlement, sir, the court is not discouraging.
I want to impress upon him since personally.
Do it.
Sir,
Do it, but deke apne vitre.
I'm appearing for the informant, your wife manner, opposite party wife manner.
Okay, say
We have also filed a RPFM. Both of them will be taken up together, my lord.
ठीक ଅଛି just ଏଇଠି ଗୋଟେ ଆଗ ସରିଯାଉ କେବେ ଆଣିପାରିବେ ଏଇଟା ତାଙ୍କର
A short date, it can be
adjudicated.
either finally settled either this way or that.
Whatever, sir, adjournment is not preventing the settlement. Please appreciate. You are portraying as if the matter is adjourned, then it will be not settled. Settlement is your side.
I am trying.
I'll be most happy to find that you say and note that it is settled. Is the court preventing in any manner?
No, court is not preventing. Because he's coming on Saturday, I want to personally impress upon him to settle what will be the pros and cons of the result of the case. Since the other side has already appeared that they have also filed a case. Both the case first week of May, first week of
commencing 4-5.
Obliged. They
made 6 adjournment to obtain instruction. Accordingly, the matter shall be listed in the week commencing listed for fresh admission in the week commencing 4-5-2024. Mr. SS
Siddharth SG Das. Siddharth Gautam Das.
Mr. Siddharth Gautam Das, learned counsel, submits that
Yes,
he has instructions to appear on behalf of the opposite party.
And we have also filed a
He along with the learned associates have filed their wakalatnama on
20-4-26.
The wakalatnama shall be tagged to the records, scanned copy be updated. Name of Mr. Learned counsel for the opposite party shall be mentioned in the cause list as well as the case brief. Stop. It is submitted by the learned counsel, Mr. Das, for the opposite party, that the opposite party has filed RPFAM
number 141 of 25.
141 of 2025, arising out of the same judgment.
No.
Stop. Both the matters shall be listed together from the next date of listing. Liberty to mention, Mr. Balakrishna, if you arrive at something,
I'm
Mr.
trying.
Das, you talk to Mr. Balakrishna, you can always mention. Liberty to mention.
Because totally personal in matters. That's why.
I know. You told that.
That's why I'm trying my best. I'll try my best. If it comes out successful, I'll be happy.
Let us see. Trying, it is worth trying. Always, matrimonial matters is always worth trying. Because in our concept of law is also that it is a sacrament.
Item 2.
Mr. Gopinath Sethi for the petitioner.
Contemner is there from ITCO. State is not.
ITCO को कौन direction थी लगी? Who direction?
The petitioner applied for a allotment of government land.
Question sir कौन? ITCO को कौन direction थीला sir? Direction टा देखा तू?
Direction
कहते जे ITCO.
Minor.
So ITCO रो कौन role थीला? कौन direction थीला? टी सेठी तो कहिबे.
Minor page 11. Minor. The petitioner shall have to liberty to make a representation afresh, enclosing copy of the representation along with all supporting documents to appropriate authority of ITCO for consideration of grievances. The authority shall do well to dispose of the representation taking into account the RTI
Representation disposal.
minor.
Had learned counsel for the petitioner, stop. The petitioner Alpara, the petitioner alleges non-compliance of the order dated 25/9/2024, passed by this bench, disposing of WPC number 19062 of 2024. It is submitted by the learned counsel for the petitioner that the petitioner has communicated the order passed by this court, which was received by the opposite party authority on 1/11 na 1/10.
1-10.
1/10 ତାଙ୍କ handwriting ରେ 11 ଭଳିଆ ଦୁସୁଛି 1/10/2024 stop. It is further submitted that despite the order being communicated, order having been communicated, the opposite party is not opposite party has failed to comply. Stop. Issue notice to the opposite party, alias contemner, by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 7 working days. List after S are liberty to mention.
Item 3.
May I please?
Yes, please.
My lord, annexure 2.
This is the same matter which is being argued.
No, some different.
No,
This is transfer petition.
Parties.
Same parties.
So it has to be taken up together.
My lord, this is for transfer.
Correct. At least the judge is not a TRPC, I understand. So the TRPC has been filed by the husband in the marriage, seeking transfer of the CP number where checking out?
But this is filed under section 24 of the.
I'm learning. I learn.
Sorry, my lord.
I'm learning. No
Sorry.
difficulty. What is the? Have you read 24?
My lord.
So what 24 says?
Transfer of petition. As per the direction of this honorable court, if there is some contingency arises or if there is a violation of natural justice, then
There.
also
Contingency and natural justice is there.
no, natural justice is a matlab broad scope, which is not.
Nowhere,
Which is-
nowhere. It cannot be.
So, my lord, may kindly.
Natural is not an ingredient.
My lord,
Then what is appeal?
from the main order.
So whenever when there is a
Section-
violation of natural justice, who will win? The opposite party will win. So you want to win or lose the case?
Everybody have a.
Yes. You are the opposite party or the petitioner there?
I am the petitioner here. In this transfer
Never,
petition,
never second guess any provision. Make a experimental litigation.
this is not.
Contingency and natural justice is not mentioned in section 24.
My lord, that's why my lord may kindly give a liberty to file an amendment petition. Read with 226 at least.
Liberty cannot be given by High Court. Lacks complete lack of jurisdiction.
Then my lord may kindly take up this transfer petition
Understand.
any other day.
No. On the same day, because there is a problem. Multiplicity of proceeding has a problem. Because the same court passing different orders has a problem. And you have imagined certain provision in section 24. It is not there.
That's why.
So the imagination never helps.
My lord.
Because CPC is very, very, very specific.
In this petition,
You are the opposite party there.
in transfer petition. In
Suit, civil suit, CP, matrimonial.
matrimonial one filed by the husband.
Is
under section
TRPC is which CP? What is the number of the CP?
14 of 2024.
You are seeking transfer.
My lord.
Prayer page is?
Page 6. 14 of 2024, in which I am for the petitioner, and MAT case number 49 of 22, in which I am for the opposite party.
Multiple prayers are not maintainable. That's to be dismissed.
Then my lord may kindly give a liberty to file a better.
Liberty is not to be granted. It has to be. You see, the liberty cannot be curtailed. Whenever High Court is the authority to grant liberty to file any suit or a section 24 application, then you seek for liberty. If there is no such liberty, concept of liberty in any statute, I do not have power to curtail the liberty. Must
Then on the
understand.
self some ground totally debarred whenever I
You
make.
look at, have you brought CPC?
Today,
That's the difficulty.
sorry, my lord.
Dear Madam CPC, just. Either you look at section 24, then you will realize what mistake you have done. Can you read the prayer first? Then you read section 24.
Section 24.
थोड़ा prayer टा आगे
Madam,
पढ़ो,
madam.
थोड़ा disoriented हो.
Therefore, it is humbly prayed that Honorable Court may kindly graciously be pleased to transfer MAT case number 14 of 2024 filed by the husband petitioner under section 13 Hindu Marriage Act.
So read slowly.
Madam.
Then second prayer is
Transfer MAT case number 49 of
49.
49
Then see
22,
execution case 41.
41. Adjudication
Then
case number
54. On allegation of
which is pending, which is at Annexure 2, Madam, page 16.
on the allegations कौन 24 है कौन apprehension है कौन
24 regarding that I'm unable to get justice.
allegation against the judge.
My lord.
Can you make that allegation?
My lord.
Which case law?
My lord, in page, may kindly see Annexure 2, my lord.
Make submission. I will see. Make your submission. What is the basis of allegation against the judge?
If there is a rule against biasness, doctrine of bias.
Which provision in CPC or?
There is nothing, any provision in CPC.
Bias?
Come under the natural justice.
Which article or which provision of this?
This has come under natural administrative law.
Administrative law, very correct.
My lord.
Which ever Supreme Court decision or whichever thing has dealt with allegation of bias against a judge?
No, my lord.
So the problem is administrative law operates in which field?
This is a large scope. There is a large scope.
Not large scope. Administrative law operates in which field?
When there is a.
May I give you a hint?
My lord.
Why there is a procedure? What is the difference between CPC and administrative law?
CPC, it is a code and that is not a code.
Correct. Absolutely. Brilliant. So administrative law is meant for review of judicial review of what?
Judicial review of the
administrative action.
My lord.
Now, does the court have power, constitutional court, to review the judicial action, divorce CPC, or maybe Family Courts Act?
No, my lord. Against
so you must understand that if there is any you have to file a petition.
My lord.
Whatever contingency, that is the reason the procedure provides that whatever grievance you have, because you are not telling, though repeatedly I have been asking you, what is the allegation against the judge?
My lord.
So you say that you have a feeling of bias.
No, feeling of biasness, there is much appearance in my lord. May kindly see page 14 on dated 2. This is a time petition filed by me. When my amendment is disallowed.
Kindly read the order.
My lord. This is not order, this is the time petition, page 14.
Okay.
Which is filed by me on dated 2/4/2026 before the Judge Family Court. That I want to going to challenge the order which is passed by Honorable Court. But without consider the same, so directly on page 10, he stated that I am file Hazara. Madam, may kindly see page 10.
So now suppose I, Mr. Lenka, Mr. Mohanty, can I take your name?
Yes.
Please. So kindly take your seat. Mr. Lenka, I am so many times taking his name, so he may be unhappy. Now, now Mohanty stands up. Your matter is?
Next.
He now stands up and says, my lord, I am going to challenge your order before Supreme Court. Grant me adjournment. Now, does this court have jurisdiction to grant such a prayer?
No, as per his willingness, he
you are
going to challenge or not?
Please develop the habit of listening, then you have to answer.
Sorry, ma'am.
Mr. Mohanty is making a prayer, adjourn the matter because I am going to challenge this order before that. Now, writ appeal is available. Writ appeal, or it is 227 and I go to Supreme Court. Does this court have authority to pass any order?
No, my lord.
That's the problem.
But
So
give
now
adjournment.
kindly again you have started speaking. Now Mr. Mohanty goes to Supreme Court. He may go and say that it is misconduct on part of the High Court judge. When I mentioned the matter that I will challenge before the writ appellate court, division bench, fast court, maybe now the second court is taking up writ appeal. He is not adjourning the matter. Because why? The answer is very simple, madam. There is no such provision.
My lord.
That this court doesn't have a power to adjourn because there are two parties. There are two parties. The matter is not at the whims of any of the parties. More importantly, not at the whims and fancies of the court. So if the court passes a reasoned order, so now suppose you are saying the second aspect. First, the conception, what you are saying that the seeking time petition would have been rejected.
No, seeking time.
Please appreciate this. Time petition can be rejected. That because you have stated that you want to challenge the order. Correct. So it will be rejected. Now the court has only said, instead of rejecting it, says files hajira. So court has favored you or passed an order against you.
Order against me.
In favored you. Because rejection of a time petition, if you look at CPC, any adjournment sought for is not to be granted. You must understand. Because there are strong views of Supreme Court regarding adjournment. Seeking adjournment in a proceeding, now the CPC has been amended and Supreme Court has defined adjournments. If you read, you can find those decisions. Second aspect, the problem is that now suppose you are agreed by an order, any order of any court.
That is a provision of appeal.
No, appeal, revision, review, whatever. Whatever. So that even Mr. Mahan cannot allege that I'm biased.
No.
But he knows for sure.
No.
Because I meet Mr. Mohanty often. I have promised him that whenever your matter is listed, I will see how you are getting your order. He knows that.
No, this is not a question of biasness, my lord.
So now he knows it. No, I'm just trying to explain it.
My lord.
Mr. Mohanty knows because he always meets me. He has been my long-standing colleague. We meet often. I have some grievances.
My lord, in other cases also.
But the problem is that I did not obey him. Or I obeyed him, sir, but genuinely I was inconvenienced. I provided him with a glass of water after 5 minutes. So he said that I will see you. But those pleas are never taken. You will not find. The reason being, if you read the case law, the books, bias is easiest to allege, almost impossible to prove. Unless you have a direct allegation of bias, personal bias, not subject matter bias. There are bias of several types. Now we have gone in a judicial adjudication between two parties. What kind of bias you can allege against a judge? How many kind of bias you have read?
My lord, just I go through this.
Let me tell you, because we are consuming time. Today there is a paucity of time. Even if I continue till 1:30 still. Which kind of bias you have alleged against the judge? Any kind of bias you have alleged?
My lord.
What bias?
He is totally personal commenting when a proceeding is going on. He directly told me on camera proceeding that you are a lady and how you are going to take this type of plea. Whenever you take the adultery plea against the wife, then how...
You are the conducting counsel there?
I am the conducting counsel there.
Then you should engage, should not appear. Now I realize that.
And my witness also, he threatens that how these are going to be approved by...
Madam, then you should not. You should engage the senior counsel. Somebody like Mr. Mohanty. Please don't again take personal. Because he is, whenever you are making a submission before a court and the court discusses with you, we become emotive. Because in this matter, I find after hearing you for now, I have completed around 2.5 hours.
This is the hard day, my lord.
2.5 hours.
My lord.
So your contentions are not legally sound. Lack of preparation. Lack of one thing you said that you have not practiced under senior. Don't my audio स्मॉल ए देखो ट्रांसफर ऑफ एनी सूट अपील और अदर प्रोसीडिंग बुझले सेटा प्लूरल नुह काइंडली मार्क इट not plural.
Before it further trial or disposal to any
So
court.
for every suit proceeding, it has to be a separate 24 application. Now kindly mark.
Madam, we can't.
Just read the no. Since it is adjournment, I just giving you a kind of suggesting to read it. Look at 24 first opening sentence. On the application of any of the parties, correct?
Parties, and after notice to the parties, and after hearing such of them as desired to be heard, or of its own motion,
No, that correct. I want to show you something else.
and after notice to the parties, on
Yes.
the application of any of the parties, and after notice.
Convenience से देखो तो कोड लिखा है. Straight away go to the convenience word. B रे अच्छी 3B रे proceeding for the execution of a decree or order. So अपन multiple करी परिवे. It is again singular. Anyway, we will discuss tomorrow. पर काली नहीं आसी.
But any other difference?
नहीं आसी था वो. Don't apprehend that any order will be passed. पर काली withdraw कर दे. But don't do it today. After this discussion, don't do it today. Yes, simply answer.
Item 4.
This TRPC I have prayed for transfer of a suit from Cuttack Sub-Judge Court to Bhubaneswar Sub-Judge Court. The Cuttack Sub-Judge Court which is sought to be transferred is at Annexure A, page 10, CS number 207 of 2026. Lordship may kindly see.
खाली ये कौन सी one और कौन है ना दूसरा counter 8 है ना Annexure 1.
Annexure 1. Oh, I'm sorry.
In a lighter weight.
Annexure 1. I'm sorry. I'm extremely. Annexure 1 टा होची Sub-Judge Court Cuttack ର plain टा. ସେଥିରେ ଦେଖନ୍ତୁ sir, kindly see the schedule of property at page.
This is a civil suit.
Civil.
Then it notice has to go.
Yes, notice. भुवनेश्वर सुट टा सर 17 मसिया सेम पार्टिंग भितरे सेम प्रॉपर्टी
दे बायस फेस कोई के आरंभ करिवे
ना ना मोर किछ नै मोर गुटे सेकंड खाली कहू सर
I got the point.
सेथिरे सेम
property in both the cases.
Both the
saying that
सेथिरे डिक्लेरेशन प्रेयर एथिरे पार्टीशन प्रेयर एटा कॉन्फ्लिक्ट ऑफ डिसीजन हे जिवो जदी दीटा कोर्ट रे अलग अलग करिवे तेनो पुराना सुट टा जोटी पेंडिंग अछि मु चाहूते सेठी से माने भी सेठी फाइट कर नो प्रेजुडिस विल बी कॉस्ट टू द ऑपोजिट पार्टीज बिकॉज़ दे आर फाइटिंग द case at Bhubaneswar.
So Devakanta Mahanti for the petitioner, opposite party blank. Hard learned counsel for the petitioner. आपण गोटे जगह रे हबो कोन सेटा कटक हबो कोन नांती
भुवनेश्वर हबो ना सेटा पुराना सुट
दोन जीवन समय होची
ना मोर नाही फॉर द प्रैक्टिस सर काहे कि मु कहूची सेटा 17 मसिया रो
usually in case of a two suits it can be at one place. ठीक है आसन से आसन देख
आसन सेठी भुवनेश्वर ता तांको भी सुविधा हमको भी सुविधा ठीक है सेटा पुराना सुट्टा बोली मु कहूची सेठी गले दैट इज बेटर.
Hard learned counsel for the petitioner, it is submitted that CS number 207 of 2026 is pending
in the court of this
before the civil judge
senior
division first court Cuttack. Stop. आपरे लिखिबे it is further submitted CS number 113 of 2017 and CS number 634 of 2013 2013 are pending before the civil judge into bracket senior division
LR and LTV
comma LR and LTV
Bhubaneswar
all capital देखिए लिखिए भूल भाल करिए
but the same suit proper
Subpara. The learned counsel for the petitioner refers to the schedule of the properties mentioned in the suit to submit that. Both the properties. Both the properties involved in all the three suits. Identical or similar?
Sir, same property.
Are same. Are same.
Although the prayer is different. Here,
Although-
partitions are declaration.
Although in the suit pending at Cuttack, the prayer is for
Partition.
and suits pending at Bhubaneswar are suits.
Sir, suits no. Gotiye suit ta declaration. 117. Aro suit ta sir, seta eviction seta.
Okay.
Only civil suit gotiye thau sir. 113 by 17 sir.
And one of the suit pending at Bhubaneswar
Is for declaration.
is seeking declaratory relief. Madam, this is what a lawyer has to make. One sentence is enough. You see, that cuts the ice. You don't have to go beyond that. And suppose you would have stated regarding the family background of both the parties. I could not have told no, you would have taken half an hour. Then family background of both the three judges, another half an hour.
It is senior counsel matter that I am just entering into this.
No. So that is how I was telling you. Please have. No. She's right, sir.
But
You have spent sufficient time.
being a fresh lawyer, she has submitted like a experienced.
They have to verify.
There is
ସେ ହେଇଯାଇଛନ୍ତି ମୁଁ ଯାହା ଭାବୁଛି ସେ judge.
One of the suits pending at Bhubaneswar.
Yes. But accordingly, it is submitted that that suits should be tried at one place, and
Bhubaneswar.
the suit in Bhubaneswar being the older,
Yes.
the learned judge at Bhubaneswar should try all the suits. Try all the suits. Issue notice along with this order. Requisites for issuance of notice to the opposite parties.
Sir, ସେଥିରେ proforma ଅଛନ୍ତି for the time being dispense with
the
opposite party number 1.
Notice be issued to the OP number 1 by registered by speed post with registration and proof of delivery. Stuff. Requisites for issuance of notice be filed within 5 working days.
କାଲି ବି ଦେଇଦେବି
5 working days. List after SR, liberty to mention.
sir proforma opposite party ଙ୍କ ପାଇଁ notice ଟା dispense with for the time being.
ତାଙ୍କର ଲେଖିବାରେ
ଆଜ୍ଞା
ମୁଁ ତାଙ୍କ ସ୍ପିଡ୍ କୁ ମ୍ୟାଚ୍ କରୁଛି
ଆଜ୍ଞା, I'm
ଭୁଲଭାଲ ହେଲେ ଏମିତି ଯାହା ଡେରି ହଉଛି ଆଉ ଡେରି ହେଇଯାଉଛି
ଆଜ୍ଞା
mention. It is submitted by the learned counsel for the petitioner that the proforma opposite parties
ଦେଖୁଛି
32 may not be issued notice for the time being, awaiting appearance of the OP number 1.
ଆଇଏ ଅଛି sir.
ଆଇରେ କିନ୍ତୁ ତିନିଟା ଯାକ
ନା ନା ମୁଁ ତେର ମୁଁ କହୁନି ଆଇଏଟା ମୁଁ କେବଳ କଟକ ପାଇଁ କହୁଛି ଭୁବନେଶ୍ୱର ମୁଁ ଚାଲୁ
ତିନିଟା ଯାକ ରହୁ
ସାର୍ ଖାଲି କଟକ ପାଇଁ ମୋର ପ୍ରେୟାର ଅଛି
କାଲି ଗୋଟେ ମୁଁ କରିଥିଲି ସେମିତି ସେ କହିବେ ଯେ ଦେବକାନ୍ତ ମହାନ୍ତି ଫେଭର କରୁଛନ୍ତି
କରନ୍ତୁ ସାର୍ ମୁଁ କହୁଛି କଟକ କାରଣ ସେ ସୁଟ୍ ଟା ବି ହିୟରିଂ
ସେଇଟା କଲେ ହବନି
ତିନିଟା ସୁଟ୍
ତିନିଟା ଯାକ ବର୍ତ୍ତମାନ ପାଇଁ ଆର୍ଜ ନେଇକି ରହୁ ଷ୍ଟେ କରୁ
ମୁଁ ଆଇ ଏମ୍ ଇଣ୍ଟରେଷ୍ଟେଡ ଫର ଦି କଟକ କାରଣ ସେଥିରେ ମୋର ଆପିୟରାନ୍ସ ଅଛି ଆଇଏ ବି ଗୋଟେ ମୋର ପ୍ରେୟାର ଟା ଟିକେ ଆଇରେ ସାର୍
right. IA 124 of 2026.
ପ୍ରେୟାର ଟା ସାର୍
Hard learned counsel for the petitioner. He reiterates the submissions as noted above. Subpara, notice as above. Subpara, accept one set of process fee as well as postal requisites as directed above. ऊपर अपन रिटर्नेबल डेट लिखना है रिटर्नेबल डेट ही फिक्स टू आज कितना तारीख 22 आफ्टर वेकेशन जीवन अप्रैल 22 रिटर्नेबल डेट भी फिक्स टू
वैकेशन पर
हां बी फिक्स टू 2026 ହେଲା? The matter shall be listed in the week commencing 6/7/2026. ऊपर लिख तो लिखिए हाँ right about the returnable date as well as the next date of listing shall be as indicated above. Stop. In the interim, it is directed that
CS
upon
number
a
2
prayer being made before the learned court in season of the matter, the CS number 207 of 2026
and IA number 1/2
and IA number 1 of 2026
arising out of the sets.
arising out of the said CS shall be adjourned beyond a date 10/7/2026
So blessed.
as would be convenient to the learned court in season of the matter. In view of the above interim order passed in the application, in the fitness of things, the CS number 113 of 2017 pending before Bhubaneswar. This is a good court.
LR and LTV. हाँ दीटा को सेम कोर्ट रहा इटा तासार चली गले बेटर.
There are revision. CS number 113 of 2017 as well as CS number 634 of 2013 shall be adjourned beyond a date shall be adjourned beyond 10/7/2026 by the learned courts in season upon a prayer being made for the said purpose.
Item 5,
Mr. Dr. S. are liberty to mention the lecture.
May it please your lordship.
Yes, please.
So
Mr.
this,
Satish Kumar Patnaik for the petitioner.
this writ petition is filed against the impugned order dated 6th December 25, passed by the learned chairperson.
It's a grounds of challenge. State away copy that.
My lord, a little bit fact is necessary to understand the matter. It is an auction sale on the surface.
Which are the decisions on this point? Interference with local adalat matters.
Yes.
Local adalat orders, judgments,
Yes,
decrees. Which are
My lord, this particular matter is a surfacey sale, under sale under Surfacey Act. So the petition.
that we are not discussing. I asked you that
No, so far there is no such decision. I could able to trace.
kindly
So far
check,
this surface.
check. This is no more res integra. Larger benches of Supreme Court. Jalor Singh
My
versus State of Punjab. Then that construction. Vargavi construction. Then
My lord, two legal issues involved here. Very simple.
so now the problem is that if you have started arguing the facts, you have no case. Appreciate this.
My lord, I'm not talking.
You have to check the before arguing finally Jalor Singh, Bhargavi construction, then latest. I find that I have also become disorganized. That much I can say.
My lord, this is against
When you are arguing the point, I have to suggest.
permanent Lok Adalat
So-
is interfering or assuming the jurisdiction on a matter arising out of a Surfacey Act. The
Correct, sir.
Equitization Act is a
Correct, sir. The problem is that a lot of effort is made. Why the Supreme Court has interfered? Why the Supreme Court has passed these guidelines? The reason being that a lot of effort is made to achieve a local adalat settlement. Suppose the permanent local adalat has interfered. Now your answer be that you never participated in the local adalat. No opportunity.
no, we didn't agree to the settlement. What
So-
was formulated by the
When I asked you what is the ground, your answer is Mukund Bhavan Trust. So your answer is that we never agreed to the settlement. Correct.
we never agreed.
So for that, how do substantiate win the challenge? This much. One sentence is enough.
My lord,
Now suppose you have signed. then you have to say why you have signed or what was the context of the signature,
Yeah.
or can be possibly you have never signed. So your reply should be pat. I mean, pat comes the reply. We never agreed.
We never agreed, yes.
So how to substantiate that?
My lord, for that, we need to appreciate the fact little bit. It was a property at Bhubaneswar was sold under SURFACE Act by the petitioner, who is a public sector bank at Delhi.
Sir,
My lord,
sir,
1 minute.
please appreciate. Again, you have lost the track. To prove that or to substantiate that you have not agreed before the trial court is procedural. It can never be factual.
My lord,
And let us assume the property is situated at X place. The SURFACE proceeding took place at Y place. Value is that much. So many background facts are there. But agreeing for a settlement before a court is absolutely procedural fact, which you have to say in the entire order sheet. Have you examined any order passed by this court?
Yeah.
Judgment. There is a judgment by this court, this bench. It was argued. In fact, after the notices were issued, from the order sheet, it was shown that the notice was not, it's a decree. Partition suit. Partition suit, declaratory relief. Partition is allowed. Two of the defendants' notices are not sufficient. But since there is a lot of effort made, lot of effort, money is spent also. People are noticed because we are also doing pre-Lok Adalat conciliation. I myself have attended.
Yes, my lord, I agree.
Lot of effort. You must have attended as a bank lawyer.
Yes, my lord.
Many of our colleagues, they are attending as insurance lawyers. Lot of effort is made to ask the parties to remain present, to entertain them, to listen to them informally, to arrive at a conclusion. And no Lok Adalat without basis of agreement will enter into an adjudication. Because they know, in judicial forums, they know that without agreement, they simply tell the parties that even if you are interested, you will find in Lok Adalat, many of the parties' comments are, please allow. Then we have to tell them that in absence of the other side, it cannot be done. Banks, the same thing. They come, they offer, insurance company, they offer. But at the last moment, on the day of Lok Adalat, the party doesn't.
True.
And that is the reason there is a pro forma format where both of the parties sign. They sign in the order sheet.
Yes, I know.
Because later on, a party may say, it will become difficult for the lawyer actually. Without
Once
signature, it becomes
they
very
agree
difficult for the lawyer because he is in a catch-22 situation. Party told the lawyer, I am Raji Achi. Now he signs, lawyer signs. Party does not sign, and he or she withdraws. What the lawyer will do. So in fact, those are the fallback mechanism to assure that the parties agree. So if you say that, so now
This is not the.
Now what I will do, I will simply issue notice and admission because I have been issuing notice. Disposed of one judgment also is there. So let us see how they appear. But if you must keep in mind that for challenging a Lok Adalat, there are parameters, state terms.
I will go through this, my
Yeah,
lord,
please.
as suggested. Notice and my IA is also. OP number 1 is already served. A private, OP number 2 is a private person.
Voter किसी दरकार नहीं. Voter present.
No, but the AG office is served.
Hukum 2024 into bracket 15 SCC 675. 2024 volume 15 SCC 675.
I'll go through this one.
And it has been followed. It has followed State of Punjab versus Jalor Singh, which is the larger bench decision.
But there are lordship,
Division bench.
there are cases where if the parties are not satisfied with the or agreed of the
satisfaction.
adjudication or award passed.
Being dissatisfied with the award, actually the spirit of local is that both the parties work at distance. Somebody is losing something, both the parties lose something, and both the parties to gain something. Maybe in terms of litigation time, terms of cost of litigation, maybe in terms of the convenience.
My lord, it is not a case of
Let me
taking
see,
loan and repayment. This is not that
He
case.
submitted
This is a case where
the petitioner bank represented through the petitioner is a public sector bank represented through the chief manager,
Asset Recovery Branch, New Delhi.
branch, Connaught Place, New Delhi, challenges the order passed by the permanent Lok Adalat dated 6/12/2025.
100 बार.
जो परमानेंट लोक अदालत लिखली नहीं, परमानेंट लोक अदालत कमा खुर्दा 8 भुवनेश्वर in PLA case number 24 of 2024.
This
Input
is-
order ta?
Input order Annex 970, page 71.
The said PLA case was initiated by the opposite party herein being the applicant.
No, opposite party number 2
Opposite party number 2 herein being the applicant.
is the complainant before the PLA.
Applicant, not complainant. Applicant.
Yes, my lord.
Being the applicant, stating that the applicant was successful in e-dash auction of a residential land at Kapila Prasad Bhuvaneshwar, being the highest bidder for an amount of rupees 1053,200,000. 10,53 1053 2,000 है ना. He deposited the bid amount for 25% of the amount, rupees 26,000. He was required to deposit the balance 75%. Stop.
15th March deposit. 22.
No, details are not necessary. Only brief background
right.
facts. The present petitioners were the respondents, filed their written statement. The award was made by the PLA, which is reproduced here. The application of the applicant is allowed on contest. Page 8. To challenge the above award, it is submitted by the Learned Counsel for the petitioner that the petitioners never agreed for any settlement. It is further submitted. Stop. It is further submitted that the matter being a surface high matter would not have been the subject matter of a PLA proceeding.
True. And another issue was raised is whether it is a public utility service as mandated under the law. Bank does business of lending and deposit, accepting the deposit.
That if you say that wherever you have agreed and got the benefit, you should not fire a boomerang.
No, I have never agreed, but this case,
sir,
it is a part of my written statement on maintainability.
Not getting the point. Where the bank is happy and fine with the award by the PLA, it should not argue that PLA cannot take up our matters because we are not public.
No, bank is challenging that particular, not happy, my lord. Bank is challenging that award.
Kindly listen, then it will register. You are saying that you have never agreed anywhere in India, Union Bank has never agreed for any PLA settlement.
No,
that is the question to you.
Such cases probably very rare, where a surface.
Rare or one. So how do you know that? So don't never make a sweeping statement of law in a court.
My lord,
in a constitutional court.
Right, my lord.
proceeding in a constitutional court is beyond the territorial boundary also.
I bow down.
Union Bank
I bow
before
down.
High Court is same as Union Bank in Bombay, Maharashtra.
Bow down.
You win some, you lose some. Whenever you lose, you are unhappy. Whenever you lose, you are very happy. So don't take the plea that not PLA, because that is a larger ramification. Other points are, as I've been telling, a lot of things I'm telling. If you pitch it up that high, you may fail. You should argue the best point. If you say that
I approach, my lord.
that should be your uniform stand throughout India, not for Bhubaneswar, Khordha. I'm sure that even you will not be aware of Odisha.
Sir, I'm not aware of that.
Please don't. The allotted council makes further submissions, also finding out which are alleged to be wrong committed by the court. Stop. But I issue notice along with this. Issue notice on the question of admission along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days or 7? Within 5 working days. Returnable date be fixed to fixed to 29/6/2026. The matter shall be listed for orders in the week commencing 6/7/2026. 29/6 returnable, 6/7 listing date.
My lord,
Just once. List after SR, liberty to mention. IA 947 of 2026. The IA has been filed. I have nodded counsel for the petitioner. He reiterates his submissions as noted above. Issue notices above, accept one set of process fee as well as postal requisites along with the writ petition. Stop. In the interim, it is directed that the judgment award page 9. The award dated 6/12/2025 in passed by the Permanent Lok Adalat into bracket Public Utility Services bracket closed Khordha at Bhubaneswar in PLA case number 24/2024 shall not be given effect to without leave of this court. Further orders.
Obliged.
List after SR, liberty to mention.
Highly obliged.
Yes, please.
Item 6.
Madam Naidu was
last occasion she took time to file rejoinder. Seems that she has not filed rejoinder. Lord, she may.
Sister, simply adjourn for you. Sir, Mr. Tushar Naidu for the petitioner none. The asile par na lekhi debe. Receive na. आज प्रभु कोड विषय को पढ़े प्रभु आज कोड विषय को पढ़े चल Mr. DN Lenka AGF for the OP number 1 to 7. The matter is adjourned to be listed as order. The matter shall be listed for fresh admission. The week commencing 4/5/2024.
Item 7.
Mr. SS Das for the petitioner. Opposite party blank. The allotted counsel for the petitioner files memo of date. It's memo shall be taken on record, scan copy be updated. In view of the prayer made for withdrawal of the writ application, the petitioners are allowed to withdraw. The petitioner is allowed to withdraw the writ application with liberty to find a better application. So, as prayed for, the certified copies of documents annexed to the writ application shall be returned upon the said documents being substituted by attested photocopies.
item A,
May I please, Your Lordship?
Yes, please.
Lordship, last occasion, inadvertently, I have not substituted wife of deceased respondent number 2 in his in the substitution petition filed in LA number 8 of 2016, first LA case, Your Lordship. For which purpose I have filed Order 1 Rule 10 CPC petition for implement of wife of deceased. Copy served, Lordship.
Copy they have
And,
served, my lord, but notice has to go, my lord, to the wife of the deceased respondent number 2.
ଆପଣଙ୍କୁ ବି କପି ଦେବେ ଯୋଉମାନେ ଅଛନ୍ତି।
ହଁ ମତେ କପି ଦେଇଛୁ।
Any substitution is subject to just exceptions.
Fine.
Buଝିପାରୁଛନ୍ତି?
Fine.
Court doesn't know who is the legal heir, who is not. So it is always subject to just exceptions. ଆପଣ କପି ପାଇଛନ୍ତି?
ମୁଁ କପି ପାଇଛି।
ଆପଣଙ୍କୁ ଦେଇଛନ୍ତି କପି ମିଷ୍ଟର
Copy, yes, here. Yes, he is given.
Miss Sahoo, Mrs. D. Sahoo for the appellate.
Appellate, Lordship.
ଆପଣଙ୍କୁ power ନାହିଁ?
Lordship, no, it's case of
Miss D.
2016.
Miss D. Sahoo on behalf of Amit Prasad Bose for the appellate. এটা একটা co-application টা IA টা?
IA 239 of 25, Lordship.
আচ্ছা, IA 239 গোটিয়ে?
Yes, Your Lordship.
ଆମ ଏଇଟା 138 only thing of the
138 is the petition under Order 1 Rule 10 CPC. That's it.
ସେଟା
That is under 239 of.
ସେଇଥିରେ ତ କରିବାକୁ ପଡିବ ନା notice.
138
Yes, Your Lordship. 138.
IA 138 of 2026. The IA
What?
ଆଜ୍ଞା
138 is, he is not given.
ଠିକ ଅଛି ଠିକ ଅଛି।
Dita there ହେଇଛି 138 and 139.
ସିଏ ବି ଏତେ IA ହେଇଗଲାଣି ଯେ କୋଉଟା ଦଉଛନ୍ତି କୋଉଟା କଣ ଆପଣ ବି
Lordship, dita le ଅଛି ଗୋଟେ
application has been filed under Order 1 Rule 10 of the CPC, Civil Procedure Code. To about lower court judgment ଟା court page ରେ ଅଛି for substitution of about a spelling mistake ହେଇଛି Sasi Gardia.
Gardia, Lordship. In it is mentioned correctly, Your Lordship. Kindly have a glance.
Application के भूल करिवेनी application के भूल करिवे because it may be some lawyer will take that plea that he was not made a proper party properly.
I have earlier filed an objection to their substitution petition, my lord, because they had not added the wife of the
Wife as
deceased
well.
respondent number 2 as party in that petition, my lord. After my objection was filed, they have filed this petition.
As you know, I have some difficulty in forgetting, so I was expecting that. So that is what I was asking you. Only clear? Substitution of the opposite party number 2 in the LA reference case number 07 of 2014. Decided judgment dated 30/11/2015 by the Lorded Senior Civil Judge Sundargarh. Then comma, as the said judgment is under challenge in the present appeal and the respondent number 2, who was the UP number 2 before the number 2 not before no in the LA reference case has passed away. Copy of the IA has been served on Mr. Sahoo. ଆପଣ ଟୁ କପି appear କରିଥିଲେ.
ହଁ 2 ପାଇଁ appear
Copy of the copy of the IA has been served on Mr. G.N. Sahoo, Learned Counsel, who had entered appearance on behalf of R2, who has unfortunately passed away. Stop. Copy of the IAS, an extra copy of the IAS shall be served on the Learned Additional Standing Counsel appearing for R1. ଆପଣଙ୍କର କେତେ ଜଣକୁ ସବଷ୍ଟିଟ୍ୟୁଟ୍ କରୁଛନ୍ତି?
Lordship, initially 3 ଜଣ ହେଇଥିଲେ, 2 ଜଣ ପୁଅ ଜଣେ ଝିଅ। ଆଜି inadvertently ଆମେ added has not added as part.
ସେଟା କୋड ଲେଖିଲେ ତୁ କାହାକୁ ନୋଟିସ୍ ଦେବେ ପାର୍ଟି ତ ବି ସେ ହେଇନାହାନ୍ତି।
Wife କୁ ଯିବ
ଏଇଟା
Lordship,
ତାଙ୍କୁ ଅପୋଜିଟ୍ ପାର୍ଟି କରିବା କଥା ନା।
schedule I have mentioned in my schedule your Lordship 2D. Kindly have a glance.
ହେଲେ ଆଡ୍ରେସ୍ ଆଜ୍ଞା ଦରକାର।
Lordship, schedule has been mentioned.
ଗୋଟିଏ 2D.
Yes, your Lordship, 2D. Wife of
The name and address of the proposed legal heir is mentioned in the schedule to the IA at page
Page 3, Lordship. Below the portion of prayer.
at internal page 3 of the petition. और लोग से इंटरेस्ट ठीक है ना चलो आपण देखि लेके पड़िबो एटा 2D अछि रंभा घाटिया डिस्ट्रिक्ट सुंदरगढ़ कोर्ट कल notice be issued to the proposed LR by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within
1 week.
Within 7 working days. This after SR. After the learned counsel for the deceased R2 submits that the substitution has been filed only after he has filed his objection to the
IA for substitution.
He has filed his IA to the substitution. Get the number.
IA number 239 of 25, let's see.
IA number 239 of 2025. ଆପଣ କେବେ ଫାଇଲ କରିଥିଲେ?
ମୁଁ ସେଟା ଫାଇଲ କରିଥିଲି।
Objection, he has filed his objection dated କରିଦିଅ।
17/3/26, let's see.
17/3 तो objection dated 17/3/2026 କହିଲି objection dated to the IA 248 240 241 of 2025 this chapter is sir liberty to make
Lordship, connected matter also same, Lordship. And here is also wife was not.
ସମାନ ହବ
No, your Lordship, the name of the wife is different.
next matter ଲେଖନ୍ତୁ LAA9 of 2016 ସେ ଏକା ଅର୍ଡର କୋଚନ୍ ହେଇପାରିବ R2
Lordship, R2.
ତ ମୁଡା R2
R2, the name of the respondent is different. And the wife.
ଏଟା ତ ଟାଇପ ହବ
Yes, your Lordship.
ଏଟା ଆପଣ ଯେହେତୁ ତାକୁ ତକିନାହାନ୍ତି କଷ୍ଟ ଲେଟର ସେ ତଳେ ଶେଡ୍ୟୁଲ ରେ ଅଛି
Yes, your Lordship.
appearance ଲେଖନ୍ତୁ appearance ମାନେ ଡାକିନି appearance ଲେଖିଲେ appearance को ପାଇଁ ସେ ସାହୁ then Mr. Prem Kumar Mahanti standing counsel for R1 Mr. A.K. Nanda along with Mr. G.N. Sahoo for the
Respondent number 2.
Respondent number 2A to 2D.
2A to 2D.
It is the notice.
2A 2D କଣ allow ହେଇଛି?
Yes, your lord. No, your lordship. The same
ତାହେଲେ
condition.
This has been issued manual, I have appeared.
Only two.
appear କରିଛନ୍ତି?
ହଁ ମୁଁ ତାର ପୁଅ ଝିଅ ପାଇଁ appear କରିଯାଇଛି।
2A 2D substitute ହେଲେଣି?
No, your lordship.
ନା ନା
The
ତାହେଲେ
petition.
proposed ହେଲା।
ପ୍ରପୋଜ
appearing for the proposed ହେଲା। କିଛି ଦିନ ପରେ ଆପଣ ଭୁଲିଯିବେ, ଆପଣ ତାଙ୍କ ପାଇଁ appear କରିବେ, ଆପଣ ଜାଗାରେ appear କରିବେ। ଏ ପ୍ରକାର କେସ୍ ଗଲାଣି 2016 10 ବର୍ଷ ହେଇଗଲାଣି। And you'll be surprised, Mr. Mahanti started appearing for somebody else. He has forgotten that he's the AC. So, okay. So, Kotiri mention no kari proposed LRP. Mr. Ekenanda along with Mr. G.N. Sahoo for proposed LRs. Yes.
item 9,
Yes, Mr.
Obliged.
Mr. Abhilash Mishra for the petitioner.
Here, my lord, the order of disengagement is under challenge. Lordship, the Annexure 1, the petitioner was appointed as a warder for ashram school. Subsequently, Sahoo notice was issued to her under Annexure 2.
This is a subject matter of my determination.
Yes,
What I call service matter.
yes. Service relating to educational institution.
Just EBF. ଏଇଠି ଅଛି। କେତେ ନମ୍ବର ଆଇଟମଟା କହିଲେ? କେତେ ନମ୍ବର ଏଣ୍ଟ୍ରି? କୋଉଟା ମିଳୁନି? ଆପଣ ପାଖରେ ବି ନାହିଁ? ଆପଣ କହୁନାହାନ୍ତି?
Entry number 1. Entry number 1. Petition relating to removal, termination, retirement, retrenchment, disengagement, and different categories of contractual employees.
Proceeding.
It is disengagement, my lord.
এটা এন্ট্রি 2 রে আছে।
Entry 2.
1 Yes, please.
Yes, my lord. Was appointed in the warder in ashram school, and subsequently under Annexure 2, she was served within Sahoo's notice.
Disengagement এপর্যন্ত নোটিস ইস্যু হয়নি?
No.
ହେଲା?
What happened?
So Mahanti take notice. Disengagement you have to file.
Disengagement order was assailed. Look,
Please,
my lord,
କୁହନ୍ତୁ।
disengagement order was assailed before this court. This court remanded the matter to collector, and collector again confirmed that order.
But still it is pending since 2020.
My lord, let notice be issued, my lord.
Mr. Abhilash Mishra for the petitioner. Mr. Prem Kumar Mahanti for the parties. Ashram school, Mr. Mahanti, you will be appearing because they are government schools.
yes, yes.
So Prem Kumar Mahanti, Adjudication counsel for the opposite party. The petitioner who was working as a warder in ashram school at Nuagaon ashram, who was working at
Matron, lady matron. Lady matron.
who was working as lady matron in the Nuagaon ashram school, at Noyagada, in the district of Noyagada, is before this court challenging the order passed by the OP number 1 collector and district magistrate. Who order that?
Yes,
Dated 4/8/2018. Stop. By the said order, the collector has confirmed the disengagement of the petitioner as lady matron Stop. The consideration by the collector was pursuant to the direction passed earlier by the coordinate bench.
By the coordinate bench.
Coordinate bench in WPC number 3992 of 2018. Coordinate bench or division bench?
Coordinate bench, my lord.
Coordinate bench in WPC number 3992 of 2018. Order का date का कोई परिवे?
Dates, my lord. Yes, my lord. 18 for 18. That order.
October
4
October 4 Coordinate bench it October 4 number 3992 of 2018. Now, Third Direct Counsel for the petitioner issue notice along with this order. The Lorded Additional Standing Counsel upon advance copy served appears and waives notice on behalf of the opposite parties. He shall obtain instruction and file counter in response to the writ application. How much, sir? Ms. Mahanti, how much time? By Adjudication. By May master na after vacation?
After vacation.
By 25/6/2026 upon serving copy thereof on the Lorded Counsel for the petitioner. Stop. The petitioner shall have liberty to file rejoinder to the counter. Stop. You want a date? The matter shall be listed for admission in the week commencing 20 na कितने 11/7/2024 11/7 sorry बारे 13/7/2024 liberty to mention.
Item 10.
Yes, please.
I've been requested by Mr. Dhala to
Yes.
make an adjournment.
Mr. Mahanti को कहले. Mr. Mahanti was standing here. Mr. Mahanti's submission is that nothing remains to be adjudicated. Because IA has been considered on merits on propositions of law. Though he's not there, but that was his last date, that was his submission.
Keep it to tomorrow, my lord.
Tomorrow. Anyway, Mr. Mahanti has a point that after that
Yes.
order, that nothing remains. So, Mr. Dhala now, after that, he's not appearing.
Today morning he has requested me.
Correct. Mr. A. Misra on behalf of Vishwa Prakash Dhala for the petitioner. Mr. Suraj Mahanti for the opposite party. The Lorded Counsel adjournment is sought for on behalf of the Lorded Counsel for the petitioner. By the earlier order dated 23/3/2026, the today's listing was intimated to the Lorded Counsel for the petitioner. Stop. Today again the matter is sought to be adjourned by the petitioner. Stop. To grant further opportunity, list in the week commencing 13/7/2026. Please intimate Mr. Mahanti.
Yes.
Did you talk to him?
Yes.
What he said? Any date he suggested?
No. I have not. Today I have not talked. Generally, I will inform my lord.
11.
11.
Yes.
May I please, your lordship?
Mr. Samit Kumar, Mr. Senior Advocate, along with Mr.
Rakesh Raut.
Mr. Rakesh Raut for the petitioner. Opposite party, Mr. Prem Kumar Mahanti. That's no standing counsel.
I'll just, it will be disposed of
Yes.
very short note. You written
That inquiry report is found favorable.
favorable more quality for the contention. All along my contention was, ସେମାନେ ଯୋଉ machine generated report ରେ ମତେ କହୁଛନ୍ତି ଯେ ମୁଁ no physical inquiry has been conducted. Somehow, after your lordship was pleased to pass an order on 12/1/2026, whether I can be reinstated or I can be subsequently considered, both things your lordship indicated, they physically inquired into the matter. And they have said there is absolutely no allegation against me. Now, today's situation is I am taking instruction from my friend. My assignment has been tagged. Nobody else has been appointed.
therefore, they have said your lordship may pass appropriate order. That is what they have said on affidavit. Your lordship may kindly turn to page 4 of the recent affidavit, paragraph 3. And they have said read petition.
I'll get that. That affidavit is by Himanshu Bhushan Sahoo.
Buddhadev Jena.
Sorry?
Buddhadev Jena. That's a recent affidavit. Lordship.
Scroll over.
Your lordship may take.
এটা ଅଛି originalটা ଅଛି. Your lordship can be due because this fellow is suffering.
More scan.
Or
Scan copy check करिए कि अपन physical
रियल कॉपीটা নিশ্চিত ଥିବ କାରଣ ସ୍କାନ ବୋଧେ ହେଇନି.
ଅଛି ଜାଣିଲେ
ଆଜ୍ଞା. ସେଥିରେ ସେ
ଆଉ ଥରେ ନାଟା କହିଲେ ସେ ଡେପୋନେଣ୍ଟ ଙ୍କ ନାଟା
ବୁଦ୍ଧଦେବ ଜେନା.
ବୁଦ୍ଧଦେବ ଜେନା ଦେଖନ୍ତୁ.
ନହେଲେ ଆମକୁ ଦେଲେ ଆମେ ବାହାର କରିଦେବୁ. এটা ଗୋଟେ ଆନେକ୍ସର C/5 D/5 ଥିବ ଇଣ୍ଡେକ୍ସଟାରେ. ସେଥିରେ ମୁଁ ପଦେ ପଢିବି ଫର ୟୋର ଲର୍ଡସିପ୍ସ ଆପ୍ରିସିଏସନ. In view of the above factual finding, ମାନେ ସେ ଯାଇକି ପୁରା physically inquiry କଲେ ସବୁ customers କୋଠୁ. And it is humbly submitted that the allegations as well as unauthenticated transactions are as alleged against the present petitioner are factually incorrect. The conduct of the petitioner was found to be bona fide, and it was established that approximately 9, that was my contention also, of the PDS transactions were carried out through authenticated EPOS mode with no material evidence of misappropriation, diversion or wrongful denial from malified intention. Accordingly, the petition may kindly be disposed of. ता पूर्वरु भी से कहिसंती enquiry करी report देचन feedback समस्त पाइचंती. And that was my contention in a rejoinder that was filed before the Hon'Ble.
So that order goes.
That
order goes. But regarding consequential benefit, I cannot pass any order because
I'll only humbly submit your lordship can record my submission that it has been tagged. So I can, had it been a case of somebody else appointed in my place, things would have been little complicated.
Okay.
So it's a case
they are considered for what is that called retagging or assigning you.
Assigning me after detagging because they have only tagged. So the tagging person doesn't have a right because they have not been appointed.
No, I mean that is equitable for them also. Even if because they are not disturbing anyone.
Yes,
but
exactly.
Authority, your case is that
and I have also suffered for only because a physical verification was not made. All along my contention was a mess.
For compensation karibe na kon?
Na, seita se karibe. In fact, this fellow is.
Apano busy hegle na
this fellow, I have talked to him also.
Yes.
He is, I think, so incapable and illiterate. He cannot even dream of doing that. And I think he can.
Lawyers do advise to initiate litigation.
Anyway,
I think that is in a lighter way.
And I think he is doing labor work to earn his livelihood. एथरे कोटे तम कोन commission मिले. से पळेला आउ तो किछि नाही तार चलियो. And
I mean that is the reality of
his
life.
Permitted to say, he said I can't pay you anything. But I felt obliged to do it because even if he says he can't pay, I felt I should do it.
Okay. ଦିଅନ୍ତା ସେଇଟା ଦିଅନ୍ତୁନି ସାର୍ ଦେବେ ଆପଣ ମଗାନ୍ତୁ ଆଣିକି ଲଗେଇଦେବେ ସ୍କାନ କରିଦେବେ ଲଗେଇଦେବେ
ନହେଲେ ଆଉ ଗୋଟେ କପି ମୁଁ କରି ଫାଇଲ କରିଦେବି ମତେ କପି
ପେପରଲେସ୍ ଦରକାର ଆକ୍ଚୁଆଲି ଅପଡେଟ୍ ହବା
ଆଜ୍ଞା ଆଜ୍ଞା
ନହେଲେ ପ୍ରୋବ୍ଲେମ କଣ ହଉଛି କି ଆଫ୍ଟର ଡିସ୍ପୋଜାଲ ଦେयर ଇଜ अनदर अवेलेबिलिटी ଡିସ୍ପୋଜାଲ ହେଲା ପରେ ଯୋଉ ରେକର୍ଡସ୍ ଇଜ ନଟ୍ ଗେଟିଂ ଅପଡେଟେଡ ସୋ देयर इज दिस डिजिटल
that has to be updated.
So digital file not matching with, so when during verification, because there is a process of digitization and verification. Verification, there is a mismatch. So digitization has its own, limits, you can say.
Paragraph.
And utilize the earlier order to make it brief. Utilize the earlier. Order dated 29/1.
Regarding your lordship's direction, my lord, that is order dated 12/1/2026. Clearly, your lordship was pleased to spell out that
the hard-dotted senior advocate for the petitioner.
May I just point out one thing? Why your lordship said whether it will stand as a bar? Because by then it was not known whether I will get a favorable report. So your lordship indicated both.
Yes.
Other restoration. That matter.
The petitioner is before this court challenging the order dated 13/9/2022 and 23/6/2023 under Annexure 6, 7 and 8.
Ma'am.
The petitioner was appointed as a dealer for the public distribution system commodity by the opposite party authority. ତାଙ୍କର appointing authority କିଏ है?
এটা
Collector ना sub collector?
সব কালেক্টর your lordship.
By the authority into bracket
Sub-collector, your
OP4.
In respect Kanpur,
In respect of
fair price shop,
Nishanapur village. Sorry,
fair price
in
shop,
respect of fair price shop for Nishanpur village under Onalia Grama Panchayat, Bhogarai block in the district of Balasore, the said fair price shop center code number being 0204P301. Stop. Apart from the other grounds to challenge the order, order details order dated order at Annexure 7 imputed before this court dated 13.09.2022 discloses the following. Quote kartu 13.9. This is scan kola. The order number 8 dated 23/6/2023 was passed by the collector and district magistrate pursuant to the order dated 3/11/2022. 3/11 by division bench or single bench? Earlier order, writ petition order?
by the Honorable Single Bench, your lordship.
By the coordinate bench dated 3/11/2022 passed in WPC number 27461/2022. In the appeal filed by the petitioner dealer challenging quashing of his dealership, quashing of engagement, disengagement, challenging this is disengagement as fair price dealer. On alleged contravention of clause 3 into bracket 3 read with clause 17 of the Odisha PDS control order, 201. The said appeal was numbered as PDS appeal number 42 of 2022. The appeal was rejected by order dated 23/6/2023 after recording reasons with the following observations. Page 33, internal page 3, reads in view of the foregoing discussion up to appeal is disposed of. In the present writ application, the principal ground of challenge is that whatever proceeding was initiated against the petitioner dealer, you can take your seat, Mr. Mahanti. Mr. You can take your seat. I'll take some time. Only dealer. Whatever proceeding was not pursuant to any complaint against the dealer, there was no material on record that could be adversely construed against the dealer, nor there was any physical verification to arrive at any conclusion, much less any adverse conclusion, much less to give any adverse finding. Stuff. Counter affidavit dated 5/1/2024 was filed by the petitioner. Sorry, by the opposite parties. On behalf of by the opposite parties 345 through the assistant civil supply into bracket Sadara bracket post Balaswar. The date tapokali counter affidavit date application. Right? Counter affidavit. Right?
I1 2024.
Rejoinder to the counter has been filed by the petitioner by affidavit dated 13/9/2024. Thereafter, the matter was heard on some occasions. On 12/1/2024, this court, after hearing the learned counsel for the senior advocate for the petitioner and the learned additional standing counsel, passed the following order. Order of the reproduced one. Thereafter, affidavit dated 15/4/2026 has been filed by the opposite parties 1, 2 to 4 through the additional civil supplies officer represented to the additional additional civil supplies officer in the office of the sub collector Balaswar, which is on record. So, copy of the affidavit could not be found in the scanned copy as well as the physical copy. It is the second copy, the first copy achi apar par, the second copy.
Yes.
Apar par copy achi.
Yes.
It rakhile hobo.
Yes.
ठीक अछि एउटा मेमो साहेब दे दियो एउटा मेमो साहेब कागज दियो ना the learned additional standing counsel produces a copy along with a memo produces copy along with memo of date which is taken on record. The registry shall make effort to find out the original copy file. So if the copy is not found, the copy file today shall be taken on record, scanned copy be updated. The learned senior advocate for the petitioner refers to paragraph, sir. Paragraph.
Rejoinder, your lordship, paragraph 6, 7, and 8.
Upon rejoinder.
I
refers to rejoinder.
Specifically, like physical verification. No physical verification, no consumer.
Apart from the contentions raised in the writ application. जोटा आपण एबे रिलाय करछंती टाका एफिडेविट टा को paragraph
तांका paragraph होची your lordship
he further
yes
the senior advocate further appreciates the fair stand taken by the opposite parties and refers to paragraph 2
and 3
paragraphs 2 and 3
man 2 re physical verification 3 re tankar observation je factually
2 and 3 1 3
3 re underline करछन छे.
This court also appreciates the stand taken by the opposite parties through the learned standing counsel, additional standing counsel, which is expected from administrative authorities in help of affairs, more so exercising the powers. Stuff. But in view of the categorical finding by the by the authorities as mentioned in 15/4/2026 that the petitioner's conduct is bona fide. Approximately 98% of PDS transactions, those were carried out by the petitioner being a dealer, were through authenticated small POS board. There is no material oblique evidence of misappropriation, diversion, wrongful denial, or any other wrongdoing. The impugned orders dated dash are set aside. So, as a consequence, so set aside. It is submitted by. It is also submitted and highlighted by the senior advocate that the fair price of so and so has been tagged to another dealer.
Nearby.
And no other dealer has been appointed in place of the petitioner in the interregnum. Stop. In view of the said facts, it is further directed. The said fair price of shall be again allocated to the petitioner. The petitioner shall continue to keep up to his reputation as found out by the authorities, being diligent, sincere, and honest in his transaction in dealing with the fair price commodities. The application is disposed of.
Obliged.
It is a memo sir receive kori. The judgment format is.
In fact, your lordship was saying about
15 टा कौन करिया 14 टा withdrawal. साढ़े गोटे 35 ହେଇଗଲାଣି ମୁଁ ଡାକିଦେବି 17 ଟା ହେ 17 ଟା ପଢ କହିଲେ
ସେ ଯୋଉ କନେକ୍ଟେଡ ରିପୋର୍ଟ ଟା ପାଇଁ କହୁଥିଲେ
ଆଉ 16 ଟା ତ ଆର୍ଜନ ହବ ନା ସେ ତ ପଳେଇବେ ମିଷ୍ଟର ବରିଶାଲ ଅଛନ୍ତି
Yes.
This is about 16 ଟା ଖାଲି order ଲେଖିଦିଅ Mr. Ramesh Kumar Agarwal for the petitioner, Mr. C. Barisal, ଆପଣ ସ୍ପେଲିଂ ଟା ଠିକ ଅଛି
Spelling is a.
ହଁ ସ୍ପେଲିଂ ଭୁଲ ଅଛି
May I?
C. Barisal for the opposite party, the Lorded Council for the opposite party seeks time to obtain instruction. Yes, Mr. Agarwal.
My lord, may I request your lordship that there is some urgency involved in this.
The date nebe कौन करिया today there is no page available नहीं actually some other pressing ये केवल date से आपण को पचाते date
वही कौन सी 6 साल
नहीं मो से order जो आपण को urgency को जो आपण तो कोटो जो जो छुट्टी पूर्व से चाहउछंदी 18 Lorded Council for the opposite the petitioner submits that the matter may is urgent. तापर लिखिए it shall be listed in the week commencing 18/5.
My lord, may I request your lordship? I have filed one IA, your lordship. Summer vacation are starting from May 9th, your lordship. The mother have filed an interim application for seeking.
हसु सर मैं तो बता हियरिंग करू ना मैं तो पहुंची नहीं से पर्यंत
What I humbly request you,
mention ହେଇଥିଲା ସେଟା टेक अप करू
since summer vacation window is 1 month, my lord. So I have filed an interim application. She wants to spend some time with the child during that summer vacation. So therefore, my lord, I request.
GUAP रे करी होबो GUAP रे आपनकर child to dislocate करिवा is a difficult thing. You see the recent decisions also.
My lord, me
You have to be more patient.
My lord, me kindly hear this matter on early date, my lord. That is only my request.
On the date पर 11/5 11/5 को in the week commencing 11/5
and सेत्र खाली कोठी टाइम लिमिट किछि हबो
shall be जोडे tagging shall be assigned within a period of Mr. Mahanti अपन जो असाइन करियो तम केते दिन भीतर 4 सप्ताह 3 सप्ताह 4 सप्ताह तादे जो कनेक्टेड मैटर कर देबे इन व्यू ऑफ द ऑर्डर पास्ट इन कनेक्ट GUAP 16 रीड पिटिशन कर देबे लिस्ट इन द वीक कमेंसिंग 11 ठीक है
Interim order was there, my lord, in the connected matter.
No,
Procedural interim order ଅଛି
758 and
WPC there was an interim order that a particular portion of the order is not to be given effect to.
interim order जहाँ जोड़ी थियो कंटिन्यू ହେଲା এটা লিখিবে matter is mentioned by the counsel for the petitioner. কোনটাকে উইথড্রল অর্ডার করতে মেমোটা দেখি কোন অর্ডার যাচ্ছে বল 14 বি the matter is mentioned. The matter is put in a matter is mentioned. Withdrawal memo जो আছে লিখিবে memo dated it has been filed by the order transmitted for the petitioner. The contents of the memo is reproduced here. Accordingly, the petition is disposed of. Copy of this order, some to be kept in the records. Yes, please.
So, sorry, my lord, I'm again troubling your lordship. My lord, since
No, I am not troubled.
My lord, actually,
I'm neither troubled, I'm unruffled.
my lord, just
You are troubled, so I can't help it.
my lord, because the only predicament is, my lord,
11 ଆସିବ ମାନେ ଆପଣ ଚାହୁଁଛନ୍ତି after vacation.
first week of May, if you're first week
I am giving earliest dates,
my lord.
and earliest the matter can reach.